Everybody, are you ready to start? I've done it again. I forgot to pack another pair of shoes. These ones, the ones I'm wearing today, do not even match my outfit. I walked my dogs before I left home and then, yeah, there you go. But at least you know that my dogs are not crying here. Shall we start? Today we're going to mix it up, do a couple of different things as we go, and we're going to run through consideration. I know all of you are exhausted. We really are at the business end of semester, and this is one of the busiest weeks that we have because we're going to meet again on Saturday at 2 o'clock in the afternoon, because I think you probably need to have a sleep in, and I like to go and do park run and go out for breakfast and stuff like that. So it's all about me, really. No, it's not. It's just an experiment. We always, if we have makeup classes, they're usually Saturday mornings or something like that, and often people don't come. And I want to know if it's me all the time. So if you don't come, I will know it's me. I just thought 2 o'clock might be a better time. I am interested, for those of you who are here, because I sort of work on the basis that those of you who are here are most likely to be the ones who come on a Saturday anyway. I need to give you the room details, which somebody emailed me today, so I'll give them during the break. But I am thinking about whether or not I should run the Saturday class using the same tech that we use for the online shoots, and whether people might actually just want to do it from home, or whether you're happy to come in and do it together. I think coming in is better, personally. I'm not going to put this part on the recording.
3 hours, isn't it?
It's slated for 3 hours because it was slated as 3 hours before I found out that we had to move these ones to 2 hours, and I've planned it as a 3-hour class because we've got 2 topics that we're going to cover. So
I think coming in.
Yeah. And to be fair, though, the lovely thing about those topics that we're going to do on Saturday is they really close off what an agreement is. And I know at this time of the semester, often I have a number of students who will be quite stressed because they're thinking we've been moving really slowly, and they're sort of anticipating that every topic is going to be the same as the ones we've done, and we've taken 2 weeks for all of these topics. But when you think about it, actually more than half of last week was taken up with assignment feed forward anyway. And because you know nothing, Jon Snow, you know nothing at the point that you start, we have to spend a lot of time talking about offer and acceptance. And the thing that I think you already know about an offer is that it needs to contain all of the DNA of the deal, for want of a better expression. So from the offer, we need to be able to glean what the consideration would be. We will also need to be able to understand if there's intention and if there is certainty. Even though we haven't dealt with those things very much, I mean, an offer by very definition is something that is on its acceptance creates the deal. So that something needs to be sufficiently certain to indicate that on acceptance the other party will understand that there's an intention to enter into a legally binding relationship. And in order for it to contain all of the things that we need, for just somebody saying, yes, I'll do that, to create, to be the mythical sperm that hits that egg and creates the DNA of this deal, that means that we need to know what the core terms are. And we know already that you can't have a legally enforceable agreement without consideration. So one of the things that we've got to now when we talk about consideration is about an exchange of promises. So it feels awkward. We've been looking at this kind of jigsaw where we've been examining each of these individual pieces in massive, massive detail, and we're starting to slot them together. And what will be great by the end of next week's topics, the next lot of topics, so the weekend, is that we will have seen all of the key bits. We'll be able to make sense of the picture, I hope. So for those of you who are listening or otherwise, I will make the offer available to I'll be in the classroom, right? I don't know what classroom it'll be yet. If it is technically possible for you to be participating online, I'm happy to try and make that happen because we'll have a bit of time to do that. But if you can be in there, and I've made it very clear to our OUA colleagues that they, if they're available and want to come, that we will make them welcome, because I think there is great benefit in being together. But I also understand there are people in this group who have small children, elderly parents, lives, sports, people that they need to be with, and that the getting in and out can be the thing that creates the difficulty. So if we can do it in a way that works for everybody, I'm happy to give that a go. So today, what I want to do, I've kind of interlaced a few little quizzes as we go through, and I had one promise that I made, which was I would bring copies of a particular problem, and I've just realised that they're sitting in the boot of my car. Damn it, I hate wasting paper. Anyway, I should, with any luck, be able to print them during the break. We'll see how we go. But you can all access the problem. You should all be able to bring it up on a mobile device or see it. We'll be able to talk about it. And maybe I can work out how to split these screens so one of the screens can actually show it. Let's see. So, before we start, just a little bit of waiting. Quick and dirty one. How comfortable are we feeling right now about understanding consideration? I'll just give it a second or two before I actually see what people are doing. Oh, that's right, I made music so you could... Oh, no, my computer turned... Oh, no. There you are. It seemed to me that you don't like this software as much as you like Kahoot, and the difference seemed to be the music. And Kahoot has only got really small things, so let's just see how we're going here. Okay, they're little... Most of you are sitting, can you see that? That's kind of cool. Sitting in this middle space here. That's where your little places are. Got some very confident people and some not so confident people. Most people are in the middle. I'm going to read the middle as meaning, yeah, I'm pretty sure that there are other things that I know, but on the whole, I would recognise a problem that was about consideration, and I would have a starting place to work on it. So good, nothing particularly different for me to plan out of that. Except for we've got slow internet today. So let's start with one of these competitive quizzes. This is the only one. So this is one for a refresher. What you're reading is except. Now, is it letting you answer? Yes. Yay. I should have put more annoying music on. This is relatively annoying, but...
You're on your way.
20 seconds to go. So those of you at home, have a little think. Write down column ABCD, write down the one, because if you don't write it down, you will fool yourself into thinking that you're going to do something different. Okay, let's have a look. Okay, so you need to be able to demonstrate that the benefit detriment is given as part of the bargain. So it's a twofold test. Okay, the other ones either were a little bit true, so the true ones were a little bit true. Well, the first one is kind of true, answering a different question perhaps. The second one suggests that there's an alternate test, and it's not. It's a cumulative test. Nobody fell for the opposite of that. Awesome. At the beginning, makes no matter at all. What is consideration. Something required to ensure that a promise is binding. Without it, a promise will not be binding. Something given in return for a promise, or something given in return for a promise required by common law to ensure that a promise is binding. One of these is the better of the available definitions.
This isn't Murakami's.
No, this is not. This is what Spotify made for me when I was in training to go to the Katy Perry concert last year. Because don't you ever go training? Do you go training before you go to a band? Like, I don't want to be the only one who's like going, ooh, no idea. You know, like when they play the big intro and you like got no idea what's going on. I feel like it's really important. I used to be a law student too, right? Like I study for everything. You're laughing because some of you are a little bit like this. Something given in return for a promise. Okay, so again, the others are all a little bit true. All of those first three are true, right? But the final one is a much more comprehensive definition. It brings in that the consideration is given in return for a promise. It's required by common law to ensure that the promise is binding. So it's giving all of those parts of the definition. So again, most of you are there. For those who aren't quite there, think about the differences and think about, and if you want to frame a question around it now or later, about why it was that you saw, particularly this one, as being more correct than the more fulsome definition. A little bit of movement. What is meant by the phrase, consideration must be sufficient but not necessarily adequate? We have some options. It needs to be something of value according to the law. It must be equal to the value of the promise. $1 would not be considered adequate consideration. Or the benefit or detriment to the promisee must have the same value as the promisor's promise. One of these things is better than the other things. I'm pretty sure this isn't Katy Perry though. Spotify's like duping me and making me do extra study for stuff that wasn't on the test. Okay, let's see where we're at.
It's early.
Something of value in accordance with the law. How much better at these are you than you were to start off with? Like, have the questions got easier? I don't think so. I think what's happening is you're seeing the benefit of you're not feeling better. So, let's have a look at the other one, which got like almost 25% of you. The benefit or detriment to the promisee must have the same value as the promisor's promise. So what does that actually mean? The benefit or detriment, so the thing that the promisee gets or suffers, must have the same value as the promisor's promise. So in other words, that's an assumption that there is some kind of equality in value. And basically this is what the maxim absolutely says is not the case. So as a matter of the common law, there needs to be an exchange. The exchange needs to be bargained for, but the court will not inquire into value. So again, probably the key case is the Nestle case, where, and I think of that as the Charlie and the Chocolate Factory case, for those of you who remember Roald Dahl, that basically a chocolate bar is worth $1, but a chocolate bar that happens to have a golden ticket inside it, to a collector of golden tickets, might be worth an absolute fortune. So was it Veruca Salt's parents who were, instead of shelling the nuts, they had their factory shelling the chocolate bars? I don't know why, that just helps me remember it. It's like it's a nutty thing to do. So courts won't inquire into the value. Courts will assume that commercial people will make a commercial deal. And when you think about it, any contract that you enter into, sorry, that music is somewhat annoying at the moment, any contract that you enter into, almost necessarily you have to think that the thing that you are giving up is worth less to you than the thing that you're purchasing in that particular moment. So I had sushi for dinner. I think I paid about $13 for it. In that moment, I would have paid about $60 for anything that had calories in it. I was absolutely ravenous. That $13 in my pocket was not worth as much to me as that sushi that was sitting there in that particular moment. Had I paid $200 for that sushi, which is easily done in some places in Melbourne, is that a bad deal or a good deal when I could have bought it for $13 at QV from the Sushi Hub place? Don't know that it would have been terribly different. Probably would have been a much nicer place to sit. But I could have paid a lot more money for it. That's up to me. Value, the courts will not inquire into the value. The courts will only inquire into whether there's an exchange. So Nestle is the case that lays that out from the UK law, the common law point of view, and Justice Kirby's decision in Woolworths is the one that we'll look at for the reasons why. So we'll get to that in a minute.
So when it says not necessarily adequate, how is...
So adequate in that sense is in the terms of value.
So of equal value.
So, or of appropriate value. So it's, yeah, so adequate there is looking at, well, you know, this house might be worth $1 million, and an adequate price for the house might be anywhere between $900,000 and $110,000. That would be an adequate range for the price, an expected range, an adequate number. But as far as the courts are concerned, if I sell you my house that sits in that range for a peppercorn, and we've done everything else right, then the courts will still uphold that. We need to have an exchange. There needs to be something that the courts see as being sufficient. And a court will see a peppercorn as being sufficient if we've done everything right and that we are demonstrating that there is intention, there is certainty, that we have agreed that price. So similarly, somebody could pay $50,000 for a chocolate bar that's nominally worth $3, because they collect bars with that kind of wrapping, or football cards, or Pokemon cards, or rare Matchbox cars, or Star Wars figurines. They all pay way more or way less. So I'm giving you $10,000, you're giving me an original Princess Leia doll from 1977. I'm thinking I've got the better part of the deal. Right, but you're giving me a plastic doll that you bought at Kmart some time ago for, you know, $3 or something or other. So good to know that Fraser Anning is amongst us somewhere. Which of the following represent good consideration? A peppercorn, a benefit received by a promisee on acceptance of an offer. A detriment suffered by the promisee will be good consideration when the detriment is incurred by the promisee at the promisor's request and in reliance by the reliance upon the promise, or part payment of a debt or completion of an existing legal duty. Again, I'm looking for the best. Oh, and I've taken your music away from you. When you are giving feedback that I suck as a teacher, you can say I'm better off doing that than being a DJ. All right. Oh, it works on that way. Okay, wide spread of answers here. And then turn the music down again now. Okay, so all 4 of these would represent good consideration in any case, like in particular cases. But in every case, the one that is the definition is the better definition. So actually not all 4 of them. So a peppercorn can be good consideration in situations where that is what has been agreed. So in David Goodwin's little introduction video for this, he talks about the situation where peppercorns are paid every year as good rent for premises in Bermuda. But it's not a catch-all. A peppercorn won't be good consideration in every case. A benefit received by a promisee on acceptance of an offer may or may not be consideration. So the question is, consideration needs to be a benefit that is given in exchange for the promise that's made. So a benefit that's given on accepting the offer may or may not relate to the promise. The last one here, part payment of a debt or completion of an existing legal duty, by themselves they're never, part payment of a debt will never be good consideration for a promise to waive the balance of the debt unless an exception applies. Performance of an existing legal duty will not be good consideration in any situation other than performing that duty. So the examples that we might use are, remember Crown and Clark, when Mr. Clark was assisting the police with their inquiries, gave them some information leading to the arrest and ultimate conviction of a murderer. He helped them with that information because he had had agreed with them that he would give them information in exchange for a plea bargain to reduce his sentence. So he was legally obliged under his plea bargain agreement to provide that information. It's one of the bases on which it couldn't be consideration for the separate arrangement. Now there are exceptions to that. We'll talk about Lampley and Braithwaite as we move along. But as a general rule, these 2 at the bottom fall within the rules of things that aren't usually consideration. So again, we end up with the definition. Oh, there's confetti this time. Is that it? Oh no, that's the end. That's all the ones. That's why. There you are. I was really hoping never to see Anning in a position of power again, but a leader for our times. I just need to go back into our PowerPoint deck. All right. Sorry. Just help myself. So why do we need consideration at all? I just want to make sure we're all on the same page because we had some variation in that last. Why do we need consideration? Can I put it another way? Do we always need consideration?
Yes. No.
Yes, but no. When don't we need consideration?
There might be a deed drawn between the 2
We have a
parties,
deed,
or
yep.
estoppel in place.
Absolutely. So if we have a deed, then we can have a binding agreement without consideration. It is also true to say that if we don't care whether our agreement is or isn't an enforceable contract, as a matter of common law, we don't need consideration either, right? We enter into social and other agreements all of the time. Consideration basically helps us differentiate between the contracts that can be enforced and those that shouldn't or shouldn't be enforceable. It goes to the question of the validity of promises, because ultimately contract is about the end of the day. We're looking for whether there's a contract in order to know whether promises that have been made can be enforced. And the very nature of a contract in almost all circumstances is that there will be an exchange of promises. One party will promise to do something in exchange for a promise from the other party to do something else. So consideration itself, what is it? It's an element of exchange that leads to the contract being enforceable. Now, at one level, one of the reasons why this is confusing is I'm pulling it back to its absolute bare bones. But once you understand this nature of exchange and the requirement for the exchange to come, or the promises to be made by both sides, the easier it is to find the consideration and to identify the promisor and the promisee. Now, you'll notice when we talked about agreement, we talked about offeror and offeree. Once we actually have a contract, we talk about promisor and promisee. It's easy to assume that every contract needs one promisor and one promisee, or at least one promisee. In fact, every party to a contract is both a promisor and a promisee. Well, every party to a bilateral contract is both a promisor and a promisee. It's mostly the same with unilateral contracts, but not always. So in any of the contracts or purported contracts that you're examining, it's helpful to ask yourself, who is the promisor in relation to that promise? What are they getting? Who are they promising it to? And what, if anything, is that promisee promising in exchange? Because if you can't find the thing that they're promising in exchange, ding, we might have a consideration question. So again, this is the map or the flowchart that you have seen before. We start by asking that question, is there legally sufficient consideration? If it turns out that it's a deed or potentially some other promissory estoppel, but just worry about deeds to start off with, then we don't need it. We can move on and start thinking about the other elements. But assuming that it's not a deed, then we need to ask these two questions. Where is this benefit detriment? And can we be sure that the benefit detriment is in exchange? There is an exchange, it's part of this bargain. Then we've got the maxims that sit under, but if we don't meet those first tests, there's no point in going further down. And there are exceptions to almost all of these maxims that sit after as well. So when do we require it? We require it to make a contract enforceable. For a promise to be legally binding, the promisee needs to give consideration to the promisor. So you see these definitions. Consideration is the price of the promise. Consideration moves from the promisee to the promisor. I just think it is much easier to just think, okay, is consideration moving both ways? Are both parties making promises, and are those promises being made in exchange for each other? Contracts are made by the exchange of promises, and when they are, each party's promise is consideration in support of the other promise. It's easy. One of the reasons why I don't like you to continue using the word price for too long is it's easy to think of the handing over the money as being consideration. That's not the consideration. It's the promise to pay it is the consideration. Failure to pay it is a breach of contract. Actually paying it is performance of the contractual obligation. So what you say, there is an element of, like, this is just ridiculous semantics. Well, you might not think so. You might be more jurisprudential than I am. But the reason that we have these rules is so that we can be absolutely sure that we have made the contract the way that the common law is going to support it. And when you think about it, most contracts that are made are never disputed. But once we've actually got each of the elements in place, we know that we've got a properly made contract. Aisha.
So, promise that doesn't have anything exchange. Can it be a consideration?
Yeah, promise can be consideration.
Just
I promise you, you offer to sell me your pen. You promise me, you're effectively, when we make the contract, you've promised me that you're going to transfer that pen to me. And I promise you that I'm going to make you a payment. The consideration is the promise to sell me the pen, the promise that I will make you payment. If you don't transfer the pen to me, you're in breach of the contract. Handing me the pen is actually performance of the contract. The contract, the consideration is the promise. So it's very definitional. And then after you get through this subject, you'll hardly ever think about it again, but you will understand it and you will see what it means. And very few contracts, particularly documented contracts, particularly the contracts that people employ lawyers to write, happen in the moment. They happen over a long period of time. So promises are made at the beginning, at the time when the documents are signed, and then those promises are performed over time. So there is a difference between a contractual obligation or promise and the performance of that obligation or promise. Agreement that doesn't have consideration in it is called a nudum pactum, or a naked agreement, and it's technically unenforceable, generally unenforceable. So an agreement that is a nudum pactum, documented as a deed, might be enforceable against that promisor, even though there's no exchange for it. In fact, it usually will be enforceable if it's documented as a deed. You'll learn in equity that equity does not assist a volunteer, so there are still some limitations when there is no price paid or no consideration, but it's not. But then we often enter into social or non-enforceable arrangements where we do believe we have a moral obligation to keep our promises. But we're talking here about contract, we're talking about enforceable agreements. So even though you might be an arsehole if you don't keep your promise, in a social agreement you might not need consideration from it and you might do it. Interestingly, in commercial agreements, yeah, it might affect your obligations and you may still be an arsehole for not keeping your promise, but actually that's one of the choices you can make. You can choose to breach an agreement. It might have all sorts of other impacts for you and you will be in breach of the agreement, which means there will be consequences for that, but you can still do it. It'll be enforced against you, there'll be damages, etc., but you can still do it. It's not a crime. When don't we need consideration? Contracts under seal, another word for contracts made by a deed. We talked about that last time. And promissory estoppel, which again, you'll deal with that in advance contracts. For those of you really interested, have a look at Walton Stores case and read the chapter on estoppel in your book, because we do keep touching on it. It won't be a bad thing for you to have read it, but we don't expect you to understand it in depth here. The thing that I want you to know is you don't plan for a promissory estoppel. A court needs to declare that there is some kind of promissory estoppel. So when you are working out what an agreement should look like, if you're thinking it's going to be hard to find consideration, to find an exchange, don't just think, oh, well, there'll be some sort of promissory estoppel, we'll rely on that later. That's not a useful way to set up an agreement. These were supposed to be hidden, these ones, because we've been through all of this before. I just want to find my slide pack and move them along. Where are we going? Oh, I'll just have to do it quickly. Two aspects of the definition. Sorry, we've talked about this. I'm just going to do a really, really quick one. Let's go back, do another one. This time I want you to use your words. For those of you who don't get the reference, Philadelphia, Tom Hanks is constantly being asked by his lawyer, who, it's not Danny Glover, is it? Can't remember who it is, to say, explain it to me like I'm a 3-year-old. Explain it like I'm a 3-year-old. So now What is consideration? Use your own words to tell us what consideration is. I'll give you music again. So those of you at home, take a moment to write down your own personal definition of what consideration is. So some really good starts here. We've got up to 40 of them that we can play with. An element of contract law that proves a contract has progressed to a legally binding state. Both a promisor and a promisee where the exchange is of sufficient value. We need consideration in order for a contract to be binding. The contract isn't binding because of the consideration. Contract becomes binding when an offer falls in love and meets an acceptance. The acceptance is communicated before the offer is withdrawn. That's the point in time when the contract is made. But in order for it to actually be a contract, that offer needs to incorporate sufficiently what the consideration will be. So the promises need to arise out of the bargain. Promise moved from the promisee in exchange of the prize for the promisor. I suspect that might have meant to have been price, although sometimes some of us feel like it's a prize. We're winning in contracting. So yes, it needs to move from the promisee. So the person who gets the benefit of a promise needs to give something in exchange for that. Exchange of value. I would take some care about using the word value by itself. It needs to be of legally sufficient value. It doesn't need to be of adequate value. Parties exchanging promises where each party acts as a promise and a promisee, promisor and promisee in a bilateral agreement, resulting in a binding state at common law. For the reasons I said before, I would be careful about resulting in a binding state, but we need it in order to have the contract. When we use words like resulting, it sounds like it's at that point that the contract is made. Okay, I can share these as we go, but the reason for actually asking you to spend the time putting your definition together is actually they're the kinds of notes that you're going to need to take into your exam at the end of the year, because you need to be able to articulate which element is missing. It's not going to be a surprise to any of you that pretty much every problem that you face in this subject will go to whether or not there is a binding contract or not. And it might go to what the terms of the contract are as we get into the second half, but basically we're looking at, is there a binding contract? So your job is to identify which of the elements might be the one or the ones that we're in question, having a question about, and being able to articulate clearly what that element is, ideally supporting it with some case law, and why it matters will escalate your ability to get marks. But also, quite frankly, escalate your ability to communicate with your clients in the future about what a contract is and why they have one or why they don't. Question?
Just to clarify, Kath, when you're saying that consideration doesn't make a contract per se, it's that that consideration ensures that the promises can be enforced, without which the promises couldn't be enforced?
So let me just wind back. I'm hoping that got caught, and that if it didn't on the recording, that my answer will encapsulate your question. In order for us to have a contract, we need to have all of the elements present.
Sure.
Agreement, which comprises offer and acceptance usually, but if we can't find that, then there's a test where we look for consensus. Consideration, intention, and certainty. We'll talk about intention and certainty over the next coming days. We need all of those things. Any one of them missing, and we don't have a contract. For a contract to be made, and for the contract itself to be enforceable, so before it's made, it's just a negotiation and it's not enforceable. After it's made, both of the parties will have rights, or all of the parties, because there might be more than two. The contract itself is made at the point in time and at the place where the offer is accepted, and that acceptance is communicated. So that's why we did all of that work around an offer needs to be accepted, the acceptance needs to be communicated, and the acceptance needs to happen before the offer has been withdrawn. The offer, the job of the offer, which is why in my hands, when I say offer, I always seem to be holding my left hand up like a Lego man, like my little Lego claw here, like I'm holding a ball, because the offer is the big thing that has all of the DNA of the deal in it. So from the offer, we need an offer to be an offer needs to be capable of acceptance and creating a contract, which means the offer needs to have embedded into it what the consideration will be for both promisor and promisee, for both offeror and offeree. It needs to encapsulate the idea of certainty. So, and we'll talk about the three elements of certainty as we get along the road. I'm not going to spend too much time on them today. And it also needs to encapsulate the idea that there's an intention for this to be legally binding. That by accepting this, so there was that American definition that I showed you, which is one of my favourites, even though it's an American, because it says that an offer is something that a person knows that when they accept it, that they have obligations and they have rights. So I'm being really picky with you here, really picky around the semantics, but you need to get these semantics right, partly so that you think like lawyers, but partly so you can unpick the problems in this particular subject. So I'm hoping that articulated both the question and the answer. Cool. So, we've spoken about this over the last couple of days. I really want to, I will do that again, sorry. The bargain requirement, I think I already know who this person is in this class, but I could be wrong. Every semester there is at least one student who just, this Woolen Mills case does their head in. Like it's just, I don't get it, it keeps coming up, and I don't understand the case. To them, in the end, I usually say, you're going to have to stop reading the extracts, read the whole thing. It's boring, but you will feel better about it. But we're going to keep coming back to Woolen Mills. So Woolen Mills really helps us understand this idea of the bargain requirement. So from a common law point of view, the British case that's probably most helpful to understand bargain is Dunlop Pneumatic Tyre Company and Selfridge. So, and this line comes from that, the quote, can't remember Lord Justice, can't remember who it is off the top of my head, an act or forbearance of one party or the promise to do an action or to give something up is the price for which the promise that the other party is paid for. So it's the price for the other party's promise. And the promise to do something or to give something up, which is given for value, is an enforceable promise. I'm trying to turn that language into plain English. So an act relied on as consideration needs to be performed in exchange for or as the agreed price of the promise that's received in return. So the act of paying money needs to be given, or the promise to pay money needs to be given in exchange for the promise to deliver the particular goods.
Is this quite like parallel to just being you have to act in consciousness of the offer.
Yeah.
Quite similar.
It's exactly the same. Really excellent point. So Steph just said this is parallel to the idea that you have to act in consciousness of the offer. You can't just accept an offer that you didn't know anything about. They're completely consistent ideas. Well spotted. So in woolen mills, what happened is the Commonwealth Government announced a subsidy that it had paid to manufacturers for wool that the manufacturers purchased and used locally. So this is all part of Menzies' idea of we were riding on the sheep's back. Australia was going to be powerful and wealthy nation because we were going to sell a whole lot of wool. And so what they did is to make sure that the price of wool stayed up. Australia basically formed its own cartel. It had basically they had wool stores. So they would hold the wool and they would release it out at certain times to keep the price up. Many of you will have heard about this. And then they also offered to pay local manufacturers essentially, well, it's a subsidy, an amount equal to the tax that they otherwise might have had to pay if they bought Australian wool and they manufactured locally rather than sending overseas to manufacture. So woolen mills, on the faith of this, what they saw as being a promise, they set up their business around buying wool in this way, and in fact they got subsidy payments for quite a while. But the Commonwealth Government then said, actually we're not going to pay these subsidies anymore. The wool price is staying up. This policy seems to be working. We don't need to do that. And woolen mills said, oh, well, hang on a minute. We acted in reliance on your promise that we were going to get these subsidies. We went and bought a whole lot of wool. In fact, if I remember the facts correctly, they actually were paid the subsidies, and the Commonwealth Government came and said, yeah, actually we've changed our mind. So they took the money back. They actually paid it back, and then woolen mills said, oh, hang on a minute, we don't want to do that. We're going to sue you in contract for the balance. So it's quite a messy set of facts. Basically, it was held that between the Commonwealth Government's announcement, which the purported offer or promise, and the act of purchasing the wool, which woolen mills put forward as being their consideration for the promise, there needs to be, and the Latin is quid pro quo, some kind of this for that. That the act of purchasing needed to happen because the promise had been made. Here, the court found that there was nothing said by the Commonwealth that suggested that the payment of the subsidy was promised in return for purchasing the wool. The Commonwealth's announcement was just a policy. It's our policy that Australian manufacturers will pay less for the wool than that yellow peril on the outside of our seas. We were really good at racist policies back then. Could we just stop with we're really good at racist policies, or... Yeah, okay, wrong class. Leave it alone, Kath. So here they found that there was no consideration. There needs to be an exchange. If I'm going to promise you money, that needs to be in exchange for your promise to do something for me. And they didn't have that in this case. Another case in relation to this is McDivitt, which is in your textbook, much more recent, 1987 New South Wales case, where McDivitt basically had all of this land. It was all subject to rezoning. He wanted to sell some of it, but he couldn't. He was really trying to play a bit fast and loose, I think, with the regulations. And so to make it easy for himself, effectively, he said that Beaton could live rent-free on his land provided that he used permaculture techniques to deal with it, on the agriculture on the land. So Beaton lived there for 7 years. they had a dispute, which I think is hilarious. It was over Tai Chi. I'm trying to think, how do you have a dispute over Tai Chi? Like imaginary swords at dawn, like what is happening? But anyway, they had this Tai Chi dispute, which led to a great falling out, and Beaton was kicked off the land. And Beaton then demanded that the land be transferred to him under contract. By majority, the New South Wales Court of Appeal said that Beaton had no right. And that ultimately was also upheld by the High Court. Or was it? Which way did that one go?
He was acting in reliance on the offer, but that wasn't enough because there was no detriment proved.
Well done. So the judgment was upheld by the High Court because there wasn't a quid pro quo. He got to live on the land. He did what he said he would do, but it wasn't actually an exchange. He did something in reliance, but there was no bargain. So there was a benefit detriment, but the benefit detriment didn't match to the bargain in that particular case. It's a little bit complex. The judgments of Justice Kirby, Justice McHugh, and Acting Chief Justice Marnie at the time are quite different. But what is really important is relying on a promise that was made is not the same as consideration. So I make you a promise, you act in reliance on that promise, is different from us exchanging promises. The action has to come back the other way. Do you want to take a 5-minute break before we move on? And I will try and get my text sorted. Stretch your legs, have a drink.